The reason why you're handcuffed right now is like I told you, you're doing 117.
Yeah, I literally never go that fast. I have 0 speeding tickets.
At 117 miles an hour. Do you
It's
know
a fast car.
Right. Do you know they use fast new law, right?
No, I'm not aware.
Okay. So anything over 100 miles an hour or 50 miles above the speed limit, it's a misdemeanor. Okay? You understand that, right?
So what does that mean?
You're being arrested for your speed limit. Okay?
Okay.
Alright? It's not a joke, okay? 117, you're passing that car. You're in the far left lane. It's better on that car at 117 miles an hour.
Sorry.
Just because you're having fun.
I understand.
Okay?
On July 12, 2025, a law enforcement officer in Florida initiated a traffic stop after observing a vehicle traveling at 117 miles per hour on a public highway. Under Florida's recently amended speeding statute, operating a motor vehicle in excess of 100 miles per hour or 50 miles above the posted speed limit constitutes a criminal misdemeanor, not merely a civil infraction.
Are you good for? 1717.
Five, 8-1. Copy, 10 minutes. Need your license?
Do you want to just stay here?
Let me get your license first, okay? So I'm off to your 8, by the way. I'm off to your 8, by the way. The reason I'm stopping you. You know how fast you're going there on 18? What's that? You know how fast? You want me to tell you how fast you're going? You're 117. 117. Why are you going so fast? Do me a favor, pull up into the Congo River parking lot there. Hey, can I get one more? Can I get one more? I'll be in the Congo River parking lot. Caroline, is it Caroline? How about I talk to you? You got shoes? This fucking. Relax. You can take this off. How old are you? Okay.
If
Oh,
I drop my phone.
you won't get all that stuff, okay? Alright. We'll walk over here, okay? The reason why you're in handcuffs right now is like I told you, you're doing 117
Yeah, I literally never go that fast. I have 0 speeding tickets.
at 117 miles an hour. Do
It's
you know
a
they
fast car.
Right. Do you know they just passed a new law, right?
No, I'm not aware.
Okay. So anything over 100 miles an hour or 50 miles above the speed limit, it's a misdemeanor. Okay? You understand that, right?
So what does that mean?
You're being arrested for your speed limit. Okay? Alright? It's not a joke, okay? 117, you're passing that car. You're in the far left lane. It's better on that car at 117 miles an hour.
Sorry.
Just because you're having fun.
I understand.
Okay?
This distinction is critical. A civil infraction allows for a citation and release. A criminal misdemeanor permits a full custodial arrest. The Supreme Court addressed this directly in Atwater versus City of Lago Vista in 2001. The court held that a custodial arrest for even a minor criminal traffic offense does not violate the Fourth Amendment provided probable cause exists. Here, the officer personally observed the vehicle at 117 miles per hour. Probable cause was not in dispute. The arrest was constitutionally sound from the outset.
Wait, why is he being arrested?
We'll get everything squared away, okay?
Oh, did they leave the car on?
What should I have? The keys in there?
I don't know.
Is it, whose car is
I
it?
think it is.
It's your car, right?
Yeah, it's my car.
Okay.
Should be in there.
Alright, is there anything on you? Because I'm going to have a female officer come search you.
Okay.
There's nothing on you.
No, I would prefer
Alright,
to have
so
my
who is
phone
that to you?
That's my husband.
That's your husband. Alright, did he tell you to slow down or?
Yeah. I
It's not-
understand. It's fast.
Okay? There's not a place to do it, right? If you want to go that fast, there's a racetrack for that kind of stuff. Okay?
Yeah, we know.
Because what you're doing is it's racing too, okay? It's considered racing. You're an exhibition of a speed. Alright?
Sorry, I really wasn't aware. I literally never go fast.
Alright, well, just hang tight.
Wait,
we're
I
gonna-
have a question.
What do
Why
you-
is he getting arrested?
Because everybody in the car for racing, it goes to jail, okay? I'm gonna go talk to him here in a second. But that's how it is. It doesn't matter. People can walk, they be sitting on the side of the street watching racing. They can go to jail, okay?
But does that, are we like actually going to jail, or is it like
Yes.
bond out type of situation?
No, you're going to jail, okay? Just hang tight. I'll come back and talk to you in a second. What's your name, boss?
Isaiah.
Did you know she was going that fast?
I wasn't looking at the speedometer. I can't see over it, but
Right.
it felt fast.
It felt fast, right?
Yeah.
Did you tell her to slow down at all, or did you want her to slow down?
I mean,
I get.
you know,
I understand.
I'm comfortable. You know, I'm not trying to.
No, you're just being detained right now, man. You have to understand that she was doing 117, okay? They just passed a new law. Anything over 100 miles per hour, or anything 50 miles above the posted speed limit, is a misdemeanor now, okay?
Yeah.
They're not playing around, okay? She's your wife, you said?
Yeah.
All right. Is that your car too?
Yeah.
All right. Do you have a valid license?
Yeah.
Where were you guys headed to?
I was headed to pick up a car part. It was like a what do you call it? It was like a sticker for the badges. It was just like some, you know.
Is that where you're coming from?
No, I was coming from home.
You guys were coming home. You guys were going to go pick up some stickers or something.
Yeah, some stickers for the car.
All right. Just like that.
The officer cited two separate charging options. First, Florida Statute Section 316.187, the dangerous speed provision applied solely to the driver. Second, Florida Statute Section 316.191, the racing and exhibition of speed statute, which extends criminal liability beyond the driver to all occupants of the vehicle. The officer chose not to invoke the racing statute. He charged only the driver under the dangerous speed provision. This is a significant exercise of prosecutorial discretion at the officer level 1 that has direct legal consequences for the passenger. The passenger Kaiser acknowledged on camera that the speed felt fast under Section 316.191, that awareness alone could constitute sufficient basis for an exhibition of speed charge. The officer's decision not to arrest Kaiser was discretionary, not mandatory. That distinction matters because discretion exercised in one case does not create a legal right to the same outcome in the next.
Hey, Caroline. I'm just going to read you something real quick. You have the right to remain silent. Anything you say can and will be used against you in the court of law. You have the right to talk to a lawyer, have him or present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questions of your race. You can sign anytime. Exercise these rights. Not answer any questions or make any statements. Do you understand each of these rights I've explained? Is it a verbal yes or no?
Yes.
Okay. So, like I explained to him, because you guys got dogs at home, and he's got a license, he's a registered, I'm gonna let him take the car home, okay? So you guys can, so he can take care of the dog, okay? You seem like a good person. I think you just made a bad choice today, okay? Like I said, they just passed this new law. We're not playing around with these speeds anymore, okay? Like I said, anything over 100 miles an hour, or anything 50 miles above the posted speed limit, okay? You're looking at jail time, okay? So, I gotta do some paperwork. You gotta get a citation for me. I'm not gonna do the racing statute. I'm just gonna do the dangerous speed statute, okay? The 1 over 100 miles per hour, 50 miles above the posted speed limit. If I decided to do the racing charge, I can take both of you to jail, okay? But I'm not doing that, alright? Hopefully this will be your last one, alright? Alright?
Step out for me. Get you out of those handcuffs. Okay, face that way. Okay, once I get you out of this one, I want you to put this hand on top of your head for me, okay? Put it on top of your head. There you go. Alright, you can relax. Come on over here. Alright, just right here. Hang tight right here for a second.
I'm not trying to be rude. I don't understand.
Okay, because if the officer wanted to, or if I wanted to, I could charge you with racing. Okay? Being a passenger in a car, that's racing. Exhibition of speed of the vehicle, which you can go to jail too. Okay? That kind of behavior is not acceptable at all. You want to race, go to the tracks. Okay? You want to have fun doing 117 miles an hour on 19, go to the tracks. Okay? You hit somebody out here doing that, kill somebody, hurt somebody severely, just a good part of your life is going to be gone. You understand? Okay. Your wife wants to speak with you. I'm going to ask this officer if it's okay. And if that's okay, then, we'll bring you up to the window and let you speak to her real quick. Right. We're going to let you take the car.
Do you know, what's happening? What's going to happen?
Do you?
Yeah.
So, am I, sleeping there?
You may have a bond. Okay. Just depends. But I don't know if you've been in trouble before, any kind of criminal history, anything like that. Just on display, but they'll tell you what your bond is over there. Okay, it's probably a small bond, somewhere around $500
Do you
or
know,
so.
where it is? Is it the...
Yep, 49th Street. All right. So what happened is I wrote down his number for you because your phone was completely dead. Once you're able to, you'll be able to make your phone call from the jail, and you can make your arrangements on how you're going to get out and how you're going to get picked up and whatnot. Okay. All right.
Can I get a kiss?
Nope. Unfortunately. There you go. That's what you go. I was going to say. Just real low, okay? All right.
Hi, how are you? I'm Officer Atwater Police Department. I'm here just to conduct your search, okay? Do you mind stepping out for me? Have you faced the vehicle and take a step away from the car? And widen your stance for me? Okay, perfect. Anything on your person I should know about? Regular bra, or is it sport? Alright, I give everybody this discretion, okay, so don't take it personally. Anything on you at all whatsoever. Okay, any introduction of contraband into the jail is an additional felony, and I'll be happy to charge you with it if they find anything, so that's why we like to give everybody that heads up, okay? Alright, let's see.
Turning to the Fifth Amendment, Miranda warnings were delivered at approximately 8 minutes into the body cam recording after the subject had already been placed in handcuffs. The Supreme Court established in Miranda v. Arizona in 1966 that a person in custody must be advised of their rights before any interrogation begins. The key word is interrogation, not arrest. No substantive questioning occurred prior to the advisement here. The officer's pre-Miranda statements were explanatory, informing the subject of the legal basis for arrest, not interrogative. That sequencing is legally defensible, though not best practice. The officer also requested a verbal confirmation of understanding, receiving a clear yes on camera. This step, often overlooked in the field, strengthens the admissibility of any subsequent statements under the knowing and voluntary waiver standard. The pre-transport search of the driver was conducted by a same-gender officer, Officer Taylor. This reflects standard departmental practice and minimizes exposure to civil rights claims under Section 1983 of Title 42. Officer Taylor also delivered a contraband advisement, notifying the subject that introducing contraband into a detention facility constitutes an additional felony offense. This advisement is not legally required, but it is sound risk management practice. On the question of force, the officer's physical contact was limited to handcuffing and a standard transport adjustment. Under Graham v. Connor, 1989, the reasonableness of force is judged from the perspective of a reasonable officer on the scene, not with 20/20 hindsight. Given a subject who was cooperative throughout the level of force, applied soft, empty hand control handcuffs, and controlled repositioning, was proportionate and within established parameters. No use of force issue arises from this footage. Now to the grading. The deduction Miranda was delivered after handcuffing, following informal exchange, that while not constituting interrogation, creates a suppression argument that better sequencing would have avoided. Officers should advise rights at the moment of arrest, not after the arrest procedure is already underway. Driver Caroline receives a C+. She was cooperative, compliant, and respectful, and that cooperation likely influenced the officer's decision to pursue the lesser charge. However, 117 miles per hour on a public highway with passengers in the vehicle satisfies the criminal threshold with significant margin. The presence of a minor in the vehicle is a serious aggravating factor not reflected in the charge filed. Passenger Kaiser receives a B+. He cooperated fully, did not interfere with the arrest, and was ultimately released at the officer's discretion. His awareness that the speed felt fast created legal exposure he was fortunate not to face. Officer Taylor receives an A-. Her engagement was brief, professional, and legally accurate. The contraband advisement was delivered clearly and without aggression. No concerns arise from her portion of the footage. The department receives a B. The deployment of a female officer for the search reflects sound policy. Officer knowledge of the amended speeding statute suggests adequate training. The concerned Miranda sequencing suggests a possible training gap on the timing of advisements relative to the initiation of arrest. Policy clarity on this point would reduce legal exposure across all future custodial stops. Key legal lessons from this encounter. Second, passenger liability under exhibition of speed statutes is real and frequently misunderstood. Florida Statute Section 316.191 does not limit liability to the driver. Being in the vehicle during an exhibition of speed can be a criminal offense in its own right. Third, Miranda timing matters. The constitutional requirement is that warnings precede custodial interrogation, not that they precede the arrest itself. But delivering Miranda at the moment of restraint rather than after processing is the cleaner practice and eliminates the suppression argument entirely. Fourth, discretion is not immunity. The officer's decision not to charge the passenger was lawful, but subjects should understand that decision belongs entirely to the officer. Cooperative behavior influences discretion, it does not control it. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Street Bodycam, for even more police interaction and courtroom content.